I am thrilled to introduce to some, and to those of you who know Mario Reed, you know what a entertaining and exciting speaker he is anyway.
Yeah.
Attorney Mario Reed, he's a native of southern suburbs of Chicago. He earned his Bachelor of Arts with honors, I might add, in journalism from Columbia College, Chicago, before receiving his Juris Doctorate from the John Marshall Law School. Presently, he's the owner of the law offices of Mario Reed, where he assists clients with planning their affairs, buying and selling property, completing the probate process, and creating and sustaining their businesses. He is extremely passionate. Did I say extremely? I mean, he's extremely passionate about community education and outreach, and conducts several different workshops regarding a variety of topics throughout the Cook County area. I'm excited to hear from you today, Mario. Take it away.
Thank you kindly, Clerk Yarbrough, and greatest of afternoons, everyone.
We've been hearing that, Mario, around here.
Hey, Mario.
Greatest of afternoons, everyone. I do hope everyone's
all here.
Everyone appears to be that way. So we are going to get started because I know that this topic usually breeds a lot of questions. So we want to dive right in. I want to first say thank you to Clerk Yarbrough as well as the Rotary Group for inviting me to come and speak. I'd like to say thank you to Ms. Davis for assisting and making sure that we had all of the links that were necessary. So we're going to get started. And in getting started, we like to refer to this workshop as the Generational Wealth Workshop because most people create generational wealth through passing assets from one generation down to the next. So we are going to be looking at ways that you can achieve that as cost effectively as possible, and more importantly, as efficiently as possible. So we're going to go ahead and go to the next slide. For most individuals, our largest asset that we acquired during our lifetime is our home. And this is my home that I purchased back in 2015. And as soon as I purchased it, I wanted to figure out what would happen to that home if I were to pass away, as that's something in which most people are unaware of or unfamiliar with. Most people have no clue what's going to happen to the home if they pass away. So that's what it is that most people need to figure out. And thanks to the work of Clerk Karen Yarbrough during her time at the Recorder Deeds Office, we wanted to start answering that question for residents all throughout the state of Illinois. So that's one of the things we're going to talk about. And moving on to the next slide, one of the assets that most people have no clue about is their vehicle. What's going to happen to your car if you pass away today and you haven't put a plan in place? We see numerous clients who normally think that, oh, no one's going to fight over my car. And yet we see people who pass away, and then we have families who are fighting over that 1995 Cadillac DeVille that just breaks the family apart for no apparent reason other than no one put a plan in place. So thankfully, I don't have to worry about my 11-year-old daughter fighting anyone over this Toyota Camry because she will be driving it the second that I pass away, even if she's still only 11. All right, next slide. Then we have the bank accounts. And thankfully, I have about that same amount in my bank account today of $49.13. And even though it's only $49.13, I still want to make sure that it gets to where I want it to go. And this is something that a lot of people, because of that, we want to talk about how can you be sure that your assets get to where you want them to be. And then moving on to the next slide. So in the event that you have not put a plan in place and you pass away today, if you haven't addressed your house, if you haven't addressed your vehicles, if you haven't addressed your bank accounts, more than likely your loved ones are going to have to go to probate court. And probate court is a specific division of the circuit court, which deals primarily with dead people's stuff. In Cook County, there is only one probate division. You can't go to Markham, can't go to Skokie, can't go to Bridgeview. You got to go to the Daly Center. That's where the probate division is currently located for all of Cook County. The cost for probate can range from as little as $2,500 to well over $10,000. And one of the number one things people say is, I only have one house and I've got 3 kids, so I just want the house to go to them, so it should never have to go through probate. Not the case. And this is one of the number one misconceptions that people have. They believe that if you have a defined number of heirs, that's going to prevent their estate from going through probate court. So the next slide. So whenever it is that we're talking about that generational wealth and discussing how everything transfers, I like to talk about the 3 most common options that most people are aware of. And we like to use music royalty. So most of us have heard of the artist formerly known as Prince. Well, Prince, for all of his incredible talents and his foresight and his just ingeniousness, he failed to do any planning whatsoever. So he had an estate that's estimated to be worth more than $300 million, and he decided to do nothing. That's the first option. There's a good chance that a lot of us on this Zoom call have decided to follow in the footsteps of Prince. And even though our estates may not be worth over $300 million, if we've done nothing, then our estates will more than likely end up in the same place that Prince's estate is, which is in probate court. And it's likely going to be in probate court for over a decade. The next option that most of us have is that we can do a will. And there we go. And Aretha Franklin is part of music royalty who I like to reference for the will. And that's because Aretha Franklin wanted all of the respect. And in order to ensure that she got all of the respect, she decided to do not 1, not 2, not 3, but 4 different wills that she hand wrote herself. Now, I do not recommend handwriting your will. And more importantly, I definitely don't recommend sticking it under your couch like Aretha Franklin did. But Aretha Franklin decided that that was the best approach to her estate planning, so she put together a will. That's the second option that most people are familiar with and aware of. And then the third option for making sure that your assets get to who you want them to go to is typically the trust. Most of us have heard of a trust before, and the music royalty who took advantage of a trust is none other than the godfather of soul, James Brown. James Brown went to the best attorneys available to him in Georgia and South Carolina, and he created what was called the I Feel Good Trust Foundation. And he set up all of his plans for all of his assets and what it is that he wanted to happen to all of his wealth. James Brown died on Christmas Day of 2005. And unfortunately, because James Brown was a bit of a Rolling Stone, his loved ones fought over everything, including whether or not he should be buried or cremated or where it is that he was going to be buried. So here it is, over 15 years later, and James Brown's estate is still in probate court down in Georgia. So all 3 of these options that most of us are familiar with have the potential to go to probate court. And this is why the Illinois legislature changed the law in the state of Illinois as of January 1st, 2012, and is part of what we're going to be discussing on today. So now we're going to move on to the next slide. So normally we'd see a video about James Brown, but we're going to go ahead and bypass that for today. And whenever it is that we're talking about planning your affairs, the first step that you have to do is figure out, how do I own my assets? Whether it's your house, your vehicle, your bank accounts, you have to determine, how do you own your property? For any of us who are on the call who own property with someone else, the most important part of the process for you is you have to figure out which tenancy type do you own your property in. And thankfully, due to the great work of the clerk's office, all you have to do is visit the website of Cook County Clerk, il.gov. And then you're going to click on the tab that says recordings off to the right. And once you click on that tab off to the right that says recordings, you're then going to click on where it says search recordings. And then once you click on where it says search recordings, you're going to go ahead and select the 2020 search site. And you'll know you're there because you'll see the lovely Karen A. Yarbrough in her fuchsia jacket. And then you're going to type in your 14-digit property identification number. That 14-digit property identification number is listed on your property tax bill. So if you do not know that PIN by heart, which most of us don't, and I do not recommend memorizing, you can go to your tax bill, find the 14-digit PIN, and then you'll plug it right in. Once you've done that, you're then going to go to the most recently recorded deed. It does not matter what type of deed it is. It can be a warranty deed. It can be a quitclaim deed. It can be a trustee's deed, foreclosure deed, any of those different deeds. Whatever is the most recently recorded one, you're going to click on that. And the first thing you're going to look for is to make sure that your name is there as opposed to someone else's name, because it is very easy for someone to steal your home. And that's what we're going to talk about on next week. So the first thing you want to do is make sure that it lists your name as the grantee. And if you own it with someone else, it's going to say your name and whomever else it is as either joint tenants, tenants by the entirety, or tenants in common. Those are your three options. If you own your property with someone else, you'll own it as either joint tenants, tenants by the entirety, or tenants in common. It is imperative that you go and check to see which tenancy type you own your property in. Because if you own it as joint tenants or tenants by the entirety, you and that other person have to agree and decide who do you want to give your house to upon your passing. But if you own it as tenants in common, you and that other person each have to decide who you want to give it to, and you don't necessarily have to agree because each of you owns your defined share. And because each of you has a defined share, you get to decide who gets your interest, and you don't have to agree with the other person you own the property with. So you're going to be going to the deed to look for joint tenants, tenants by the entirety, or tenants in common. If you own the property by yourself, you don't have to worry about this part because you own it in fee simple. It's all yours. If you want to sell it, rent it, give it away, you don't have to worry about checking with anyone else because it's all yours. So I've thrown a lot at you, and this is the part of the workshop that I normally like to see if there are any questions. Not quite sure how we do questions via this format for you all, but if you want to put it in the question and answer window or the chat window, or if you want to unmute and ask it, you can do so now.
Okay, do we have questions? I don't see anything in the chat. Are there any questions?
I would have one.
Yes,
Okay.
sir.
We just are settling a house for my mother's estate, and we used a quick claim deed, and for us it saved a lot of bumps, it seemed like. Could you mention that one? I don't know how it's handled in Illinois. She was in Michigan.
Yes, so every state is completely different, and that's a great question. And that's something in which everyone needs to be aware of. Everything that we're going to discuss on today relates to the state of Illinois. Michigan does things very differently. They have what's called a ladybird deed up there in honor of the former first lady. In addition to that, down south, it's a whole nother world as far as I'm concerned. And they do things very differently down in Mississippi and Georgia. So each state has different sets of laws. And here in the state of Illinois, you can absolutely utilize a quit claim deed. And that's quit as in I hate my job, not quick, I'm very fast. You can utilize a quit claim deed to put somebody right onto the property while you're still alive. However, there are a lot of drawbacks to that depending upon whom you're putting on the property. There was an article that was in the New York Times not too long ago, which talked about a set of grandparents out in California who added their grandson onto the property because they wanted to make sure that it would go to him without any issue if something happened to them. Unfortunately, they didn't know that grandson all that well, because as soon as they added him onto the property, he went and took out 5 different mortgages on their property while they were still living in it, took the money and lived the good life. Well, of course, because he wasn't interested in actually paying those mortgages, the grandparents ended up getting evicted, the house got foreclosed on, and then, if not for the grace of their neighbors who raised money through a GoFundMe so that they could then buy a trailer park in the local community, they would have been homeless and out on the street. So adding someone onto your property while you're still alive and while you're living in it has a lot of dangers. Any bad thing that happens to that individual can now happen to your house. If they have a bad night at the boat, they can go out and take out a mortgage to cover those losses, and you'll be stuck with the bill. So that quit claim deed is an option, but like with everything, there are pros and cons, and it's something that you definitely want to consider before diving in. Now it appears.
Yeah, there's one question here. Does it matter? This is from Mike Rogers. And he says, does it matter what county in Illinois you own property?
So that's a great question. So it does matter what county in Illinois you own property, because Cook County is the best county in Illinois. So everyone should be owning property here in Cook County. But thankfully, everything we're going to talk about applies to every single county throughout the state. So you can use all of these tools for any assets in the state of Illinois. So it does not matter which county you're in, but you'll just go to that county, either recorder or clerk's office, in order to finalize the processes and take care of the advantages. But ideally, it's here in Cook County. All right, so it looks like we've tackled those questions. So now we'll keep moving. So we can go on to the next slide. All right, so I apologize because when I designed this slide, it was with animations. And right now, we don't have the animations going. So I'm sure this looks like a terrible hodgepodge of information. But what it is that it's attempting to show you in your deed where you can look for your tenancy type. So this top deed that's on top is from the Chins. So Hung Yip Chin and Yi Big Ho, they decided that they wanted to give their property to their 4 sons. So they split it up 25% each for all 4 of their sons, and they gave 25% to Paul, Wayne, David, and Nolan, each of them receiving 1/4 interest. In the deed itself, you'll see that it states that they're giving it to them not as joint tenants, but as tenants in common. This is incredibly important because if you receive your property as a tenant in common, your interest will then potentially go to whomever you want it to go to, as opposed to the other 2 tenancy types of joint tenancy and tenants by the entirety. That's going to go to whomever you own the property with. So that's the big difference. If you own property with someone else as a joint tenant or as a tenant by the entirety, if you pass away, your interest goes to the surviving owner. If it's your spouse, if it's your significant other, if it's your mortal enemy, whomever it is, if you die, your interest goes to them automatically. They don't have to tell anybody. They don't have to go and do anything. It automatically is absorbed by the surviving tenant. But if you own property as tenants in common, you then have to decide who you want to receive your interest, because it will not automatically go to the surviving owners. It will potentially go to your heirs, but they would have to go through probate court if you have not designated a new owner. Any questions as it relates to the tenancy? As I imagine that we probably have a few people who own property with someone else, and I cannot stress to you how important this part is. You have to check to see which tenancy type you own. Okay, so if no questions, we're going to move on to the next slide. So here is Aretha Franklin's will. This is one of her 4 wills, and it is a masterpiece if it was abstract art. But this wasn't abstract art. This was the document that Aretha Franklin handwrote in an effort to make sure that her generational wealth that she accumulated would go to the people and individuals she wanted to go to. Unfortunately, because of the fact that this is what she chose to use, now her estate is still in probate court, and they haven't even finalized who's going to be the executor, which is one of the first parts of the process. And the reason why is because in 2 of her wills, she said she wanted it to be her niece. In 2 of the other wills, she said she wanted it to be her youngest son. So because there's conflict between all of these handwritten documents, some of which weren't witnessed, some of which weren't notarized, it has created a nightmare of a circumstance that the courts are going to have to sort out for years to come. Please do not do what Aretha Franklin did and handwrite your wills and then have scratch outs and markups, because the people who have to sort it out are going to be in a world of hurt. The next slide. So this is a real life example that I like to show. And again, I apologize because I use animations and you can't see it, but this is an individual who owned a house at 99th and Yale here in the Chicagoland area. And she did a will. During her lifetime, she went to an attorney and she had a will drawn up. And most people think that if I have a will, that solves everything and my loved ones don't have to go to probate. She did the will and she stated who she wanted to serve as her executor, which was her oldest son. She had 5 children. 1 died before she passed away. So that left 4 heirs, 4 children. And all she had was a house at 99th and Yale. So she said in her will that she wanted for that house to be sold upon her passing, and she wanted for the proceeds to go split equally amongst her 4 children. She died in 2009, and they have been in probate court since then. The house wasn't sold until 2019, 10 years later. That house sold for $50,000. In the process of the last 10 years, this estate has accumulated over $12,000 worth of legal fees and court costs. So they were already only going to split $50,000, but because 2 of the siblings could not agree with the other 2 siblings, they continued to fight tooth and nail for years on end, and it ended up costing the estate what's more than likely going to end up being about $15,000. So for anyone who thinks, oh, I've done a will, I'm good, I don't have to worry about anything, my loved ones are A-okay, they won't have to end up in probate court, nothing could be further from the truth. Having a will alone does not prevent your home from potentially going to probate court. We'll move on to the next slide. Here is, like I said, the proof of it. So Miss Williams had her will and she wanted for everything to go. And what ended up happening is that you'll see on July 8th of 2019, that house sold for a whopping $50,100. and they're already up over $12,500 in legal fees. So this is a real life example. A lot of people seem to want to convince themselves that, oh, all I have is a house. I got 3 kids or 4 kids. So it's going to follow this. So I see that there are a few questions that have popped up. So the question is it better to do both will and a trust? So that's a great question. And the answer is it depends on your specific set of circumstances. Estate planning isn't a one-size-fits-all process. It is like most things in life where some people like McDonald's, myself being one of them. Some people like Mercadito, Miss Davis being one of them. So because of that, you have to figure out what's best for your situation. And in doing so, that'll determine the best route to go. Now, the next question is, why have a will and it doesn't provide estate protection? So having a will does provide certain protections, but the issue is that those protections potentially have to be enforced by a judge in the probate division. And that's the part that most people are unaware of, because if you don't do this all day, every day, you've never came in contact with it. A will was created by the Illinois Probate Act of 1975. All of the laws that pertain to that will are included in that act. If somebody needs to enforce a will, then you have to go to the probate division and ask a judge to follow what you've put in your will. And that is a very risky and dangerous proposition, because I don't know if any of you are aware, but sometimes when people die, their family members fight. I know it's very hard to believe. You've probably never seen it with your own eyes. But trust me, when people die, loved ones don't always agree about what's supposed to happen. And sometimes it gets nasty. And when it does, that will has to be enforced by the judge, which requires that it goes to probate court. And then when you go to court, guess who else comes along for the ride? Those attorneys whom each and every one of you love dearly, because attorneys are the greatest people in the world. I'm sure you're all saying that to yourself. We're going to move on to the next slide. So there was the question about the trust. Can you go the route of the trust? The answer is yes, you can absolutely go the route of the trust. But I want to make sure everyone's aware that that doesn't guarantee that your loved ones will avoid probate court either. We talked about James Brown. He had the I Feel Good Trust Foundation. He had it prepared by some of the best attorneys available to him down in South Carolina and Georgia. And his I Feel Good Trust Foundation is still in probate court over 15 years later. That's because even a trust can be challenged. And when a trust is challenged, it goes to probate court. So it's not a guarantee. It does have some additional benefits. More times than not, it doesn't go to probate court, but it's important that you understand that it can be challenged. It can go to probate court. And then there are processes that have to be followed with that. So now we'll move on to the next slide. So that was really fast moving. I guess that's my cue to pick up the pace. All right, so we'll go back. There we go. Back. Nope, other direction. There we go. All right. So thanks to the legislature, part of which Karen Yarborough was a part of when she was in the Illinois House of Representatives, as of January 1st, 2012, a law in the state of Illinois was changed. And the legislature said, we don't want for people to have to always potentially go to probate court in order to transfer their house. For most of us, our house is our most valuable asset and the largest asset that we'll acquire during our lifetime. And the legislature, in their infinite wisdom, said we need to make the process easier. We need to set it up so that people can simply add a beneficiary to their house, similar to what you can do for your bank account, your life insurance policies, your stocks, your bonds, your financial accounts, and your vehicle. and they passed what is known as the Residential Transfer on Death Instrument Act. Once again, it's the Residential Transfer on Death Instrument Act, which is sometimes abbreviated as a TODI. Well, the legislature did a fantastic job of passing the law, but as is the case with most laws that the legislature passed, no one knew about it. So there was this great law that was made available, but they didn't tell anybody because the legislature isn't really in the business of going around and championing brand new laws that have been passed. Thankfully, Karen A. Yarborough and the recorder, when she was at the Recorder of Deeds office, said, we're going to do something to educate the community about this. So that office began traveling all around the Cook County greater area and even went down to Peoria and all throughout the state and started telling homeowners and property owners about the Residential Transfer on Death Instrument. And how it works is simple. We'll go to the next slide. You have the option, so long as your property is 4 units or less, it's from 1 to 4 units. You can also use it for vacant property. You have the option to designate who you want to receive your home by simply completing a Residential Transfer on Death Instrument form. You can actually get that form from the Cook County Clerk's website. Once you've obtained it, what you'll do is you'll fill that form out. It's going to ask for the property identification number. It's going to ask for the legal description. It's going to ask for the beneficiary, the name and the address, as well as the contingency beneficiary. Everybody needs to list a contingency beneficiary because none of us know when we're going to die, and we definitely don't know when someone else is going to die. So you want to have not just one option, but you want to have a backup in the event that your first option passes away before you or at the same time as you. After you fill this form out, you then need to go and get it notarized with 2 disinterested witnesses. They cannot be the beneficiary or the contingency beneficiary. They have to be a disinterested witness. That can be a neighbor, that can be a coworker, that can be a friend, that can be an enemy. It cannot be the beneficiaries or the contingency beneficiaries. Once you've gotten that form notarized with the 2 witnesses' signature and your signature, you'll then submit it to the Cook County Clerk's office, pay to get it recorded, and you're done. You have just added a beneficiary or beneficiaries to your real property, which will ensure that upon your passing, the property will automatically transfer to those beneficiaries without them having to go to probate court, without having to verify a will, without having to put it in a trust, and ideally with no fighting whatsoever. The Residential Transfer on Death Instrument can be used for all residential real property throughout the state of Illinois, vacant lots as well as improved lots, so long as it's a 4-unit or less. If it's 5 units or more, you can't use it. There is no impact on a mortgage that you might have on the property. And more importantly, it is incredibly beneficial for your beneficiaries because if you die and didn't put a plan in place, the mortgage company will not talk to your heirs until they get the property into their name. Whereas if you listed them as the beneficiary on your house, the second you die, they become the owner. They can call up the bank and then they can arrange what's going to happen with that mortgage so that way they can continue to keep it current and avoid it going ideally through the foreclosure process. So that's a lot of information which I've thrown at you. So now I'm going to pause to see any questions. What are the tax benefits of an irrevocable trust? So that's a great question. And the answer is there are numerous tax benefits by having an irrevocable or any type of trust. How a trust works is that when you put assets into the trust, you take it out of your name and you put it into the name of the trust. The trust is a separate legal entity that technically would now need to pay taxes and so forth for any income which is being generated. Because the property belongs to the trust and not you individually, it helps prevent the individual from having to pay certain taxes based on their wealth. I'm sure some of you may be familiar with the Rockefeller family. Well, when Rockefeller was alive, one of his famous quotes was, "Own nothing, control everything." The trust allows for you to control all the assets without owning it, which means you personally don't have to get taxed because you don't own the asset. The trust also is very helpful because let's say that someone dies and they left you a $500,000 life insurance policy. Once that person dies, that $500,000 goes to you as if though it was income. Imagine if you received $500,000 right from your job. The Uncle Sam is going to want for you to pay taxes on that income. However, if that $500,000 goes to a trust and the trust now allocates $12,500 every single year to you, your children, or whomever else it is that it's going to go to, you then don't have to take a tax hit on $500,000. So those are some of the tax benefits. We can discuss a lot more of that offline if desired, but those are some of the benefits of the trust. Are there any questions related to the residential transfer on death instrument? Any questions?
I have a question. You may have already said it. So if you use one of these instruments to protect your property, then it can't be debated after you pass away. So what you put on here is what is actually going to happen and nobody can fight it. Is that the assumption?
So that's a great question. And it's close. So that's close to how it works. So one thing that I want everyone to walk away with is that everything can be fought and everything can be debated. The advantage is that by doing it with the transfer on death instrument, it limits how much can be fought and debated. And once the judge verifies that the document was properly completed, it was recorded during the lifetime of the individual, and that there were two proper disinterested witnesses, plus the notary was valid, at that point, that's the end of it. So it can still be fought and contested, but thankfully it won't take 10 years to resolve because of the fact that this was a lifetime designation. The benefit of the transfer on death instrument is that the owner is telling the whole world, they're putting it in the public record, that they want their house to go to Mario Reed. If anybody else has a problem with that, the expectation is that they go to the owner during their lifetime and say, why did you give your house to Mario Reed? If they didn't do that, the court then isn't going to go against the wishes because all of the potential other people who might want to fight had an opportunity to go and ask the owner why they were doing what they were doing. And if they didn't do that, they've waived their right to be able to challenge the wishes of the owner. So I know that was a very long-winded answer. That's my specialty.
That was good. Thank you.
The answer is that it can be fought, but it's not going to cost the beneficiaries money in court fees and legal costs because they simply show up to court, produce the document, and once it's verified as having been legally properly executed, that's the end of it. So does that answer the question for you?
Now you're unmuted.
Hello.
Yeah, does that answer the question? I believe that was that who was that speaking?
That was me. Yes, it did answer. It was awesome. Thank you. It was great.
Okay. Cody Davis has a question. What's the pros and cons if the family uses a land trust company?
Cody Davis has great questions. Great job, Cody Davis, as always. So the pros and cons of using a land trust are that there's somebody to manage those assets. One of the things that I've ran into in private practice over the last 2 years is that there are a lot of people who don't have someone in their inner circle whom they trust. And sometimes I'll say, what about your cousin or your best friend? Or they have no one that they trust. And if you don't have anyone that you trust, you won't be able to essentially have good conscience in using a trust. So as an alternative, you then can go out and hire a company to handle your affairs when you pass away. And that's what a land trust company is. You as an owner are paying a company to handle your affairs when you pass away, specifically as it relates to your house. So the benefit is that you have a third party fiduciary, which is contractually obligated to do whatever you want them to do. That's one of the biggest pros. Now, one of the biggest cons is that when you go out and hire a private company, that comes with a price tag. So there are numerous individuals who have been paying $75 or $150 for the last 10, 15, 20 years in order to maintain that company to handle their affairs. What a lot of those people don't know is that that cost doesn't have to be incurred if there's someone that they trust to carry out their wishes upon their passing. The other drawback is that when your property is in a land trust company, you don't own the house, the land trust company owns the house. So as they begin to increase fees, you have to go along, or you have to pay them to let them have your house back. So we see a lot of clients who haven't paid those trust company fees for a long period of time. And then when they go to sell the house, they have to square up with that land trust company. And sometimes it's in the tens of thousands of dollars. So like with everything, there are pros and cons. The biggest pro is that if you don't have someone that you trust, there are companies that will then step in and handle making sure your assets get to whom you want them to go to. So I see the next question of, can I address reverse mortgages and residential transfer on death? So yes, I will do that, but I want to make sure that we get to the car and the bank, and I don't want for time to run out on us. So I think we're supposed to
Robin, you know what? I thought Mario was going to be with us for 2 sessions. So I think, why don't we leave that reverse mortgage and stuff. And I also he's also going to talk about I think, what was the other thing? It was one other thing you were going to talk about, but he's not going to talk about it here because this is such a vast subject that I would really like to engage anybody and everybody who's on this call to, reach out right now, ask the questions that you have. We're going to hear from him again, thankfully, in another session. So if there are other questions, now is the time. One thing, Mario, I think it looks like, let's see, Gabriel Pecori is on the line. We reduced the price of the transfer on death instrument. And I don't know if Gabriel can come off of mute and tell us how much it costs for a toady or a transfer on death instrument.
It's $48.
Okay, and it originally was what, $100 or something like that?
Yeah, it was originally, at first, way back when the fees went up for the documents, they started charging the original document fee, which I think was $98, and then it went down to 50 something, and then when we started getting an abundance of documents being recorded, and the Cook County Board was worried about making sure that the individuals who needed to use the toady still had access to it at a minimal cost. And I think one of the commissioners referred to it as a humane act. The price left and lowered and left at $48.
Yes, so that's a substantial difference from where it started. So thank you so much for sharing this. There's a comment from Karen Thompson. She's one of our former presidents, and she says, very good presentation. Would like to get more information on the residential transfer on death instrument, and we'll be in touch. So Mario, you can go ahead and wind down. We try to get out of here by 1:30. So go right ahead.
Yes. So I really quickly want to touch on, we'll go back to the previous slide. Yes. So in the state of Illinois, you can also designate beneficiaries for your vehicle and for your bank accounts, checking accounts, savings accounts. So how the process works is very simple for those also. There is a form that's available through the Illinois Secretary of State's office that is called the Vehicle Beneficiary Affidavit. And that is a fillable form that you can fill out the details, your VIN number, the driver's license number for yourself, as well as for your beneficiary. Once you fill that form out, you get it notarized, and then you submit it to the Illinois Secretary of State's office. And that will ensure that upon your passing, whomever you've designated as the beneficiary for that vehicle will be able to take a certified copy of the death certificate into the Secretary of State, and the vehicle will transfer to them. So you can designate a beneficiary for the vehicle by a very similar process by utilizing the beneficiary affidavit form. That takes care of the car. Now, with respect to the bank accounts, all you have to do is go into the bank and tell your bank that you want to list a beneficiary for your checking, your savings, and any financial accounts you may have. Oftentimes, they will ask you for the name and the social security number of whomever it is that you're listing as the beneficiary. So you will need to have that information available and handy. But you can then designate not just a primary beneficiary, but also a contingency beneficiary. And it is to your advantage to do so. So you go to the bank, tell them you want to list a beneficiary and a contingency beneficiary, give them the name as well as the full social or the last four, and then you are done. At that point, you've now added a beneficiary to your bank account. And if you do the other steps for your vehicle and your house, you will now have designated who you want to receive your assets upon your passing without having to have them go with the will, potentially with the trust, or through the probate process. So you can add beneficiaries for your home, your car, and your bank account, which will help protect your loved ones and those assets that you want to go to who you want them to go to. So now really quickly, if we can advance a few slides. So we keep going. We're going to go past this one. Go and to the, so we can go back. We'll stop on this one. On the excellent. So this is one of the things that I have now started noticing in private practice. The transfer on death instrument tool is a fantastic tool. Hopefully people show up to workshops like this and they learn how to fill it out properly. But not everyone shows up to the workshop and not everyone knows how to fill it out properly. This is a client which I recently had walk into my office for an unrelated matter. I asked her, have you taken care of your affairs? She said, yes, I did the transfer on death instrument. I said, excellent. What's the address? I pulled up the property's address and I looked at the transfer on death instrument, and this is what was on her property's chain of title. This transfer on death instrument is not legally binding. It did not have two witnesses. The witness that she did have is also the beneficiary. So she doesn't have even one disinterested witness. Furthermore, she actually wanted her house to go to both of her kids. But because she filled it out this way, it would have went to just one unless that one died, and then it would have went to her other child. So this transfer on death instrument is representative of what can happen when you don't follow all of the details that are outlined in a workshop, and then you try and do it yourself. So a lot of people say, can I just do it myself? Absolutely you can. But like with everything, you want to make sure it's done properly. Because had Miss Glassberg not have came into my office and died, her son would have been out of this house. And more importantly, both of them would have potentially had to have gone to probate court and then spent a lot of money trying to get the house into their name when they thought that their mother had taken care of it. So it's imperative that you make certain that it's done properly, either you yourself taking the time to be diligent or working with the professional. So with that, I'm going to now stop and see if there are any other questions. If not, I'm going to return it back to the president. And I greatly appreciate the opportunity and the invitation to participate in the workshop.
Okay. I don't know what's going on here now. What is all of this? Oh goodness. Okay, so can we give it up to Mario Reed? I know he can't hear us clapping for him, but you've done an excellent job. I'm sure this will be the conversation at dinner tables tonight, you know, about this fantastic opportunity that people got to hear something that all of us need to be concerned with as it relates to transferring our assets. And you labeled this generational wealth, and that's something that people talk about a lot, but they don't do the work or they don't get it done. So thank you so much. I'm looking forward to your next presentation where you're going to teach people how to protect their assets. So with that, thank you so much, Mario. We miss you so much, but we get to see you here today, and your fan club is on, and they're clapping for you right now. So with that, let me just send it right back to the president.
Good to see you, Mario. Yeah, bro.
Great job. Can you hear me okay, Karen? Can you hear me?
Yes, I hear you fine.
Okay, good. I altered my mic slightly. Just wanted to make sure. Wow, what a wonderful job. A+ for relevancy and A+ for excellence in presentation. So we look forward to seeing you next Thursday. I've got one last announcement. Rotarians, does anyone else have an announcement you didn't get in earlier? Well, thank you all for being here today. I think there were over 30 folks present, and that's good. Let's continue to invite other guests and to invite others to consider participating in the capacity and in the work of Rotary as members of this club and committed to service above self. My last announcement had to do with our gifts to charities. I had circulated a questionnaire to application actually for charities to complete so that they could be considered in our disbursement that would be decided by all members. Today's the deadline for that. I'd like to extend that 2 weeks. So if you either did not get or didn't see or went to spam, I will send out another application for charities that you can send to your favorite charity. And it's certainly a very important process, and we hope that you all can participate, and we'll have lots of folks that probably are suffering in the amount of money that they've been able to collect to distribute services within our community, both locally and globally. Thank you everyone again for being here today. God bless you today and always. This meeting is adjourned.